Welcome to this session. In today's session, we will be talking about the procedure for obtaining a patent. As we know, patent is an intellectual property right, and how a patent is very important for a person who has invented. So today's session, we will be talking about the procedure to obtain a patent. Any person who has created something always wants some sort of reward. So definitely, the first thing which you need to do is to go for a patent. The first and foremost thing for obtaining a patent is filing of an application. The moment you come to know that you have invented something and you think that it is worth obtaining a patent or getting a patent, the first thing you should do is that go and file a patent. That means you have to go for an application, write an application to the patent office in the patent office for obtaining a patent. The patent application has to be filed by who are the persons. Let's understand who are the people who can file a patent. The first, anyone who is a true and first inventor. Now, what is the meaning of true and first inventor? The application for a patent must be filed by a person who is claiming to be the true and first inventor. The meaning of true and first inventor is that any person who has actually invented it. That means the real inventor. Now there is no definition. The definition of true and first inventor is not written in the Patent Act. But for making a person understand, I have made it very clear that the person who has filed the application first, two persons can invent the same thing, have invented the same thing, but the person who has first filed is known as the first inventor. So, and true, the meaning of true is that the one who has actually invented the thing is known as a true and first inventor. He should go and file the application firstly, and second, he should be the person who has actually invented it. Now, this filing of an application can also be assigned under Section 6(1)(b). Section 6(1)(b) of the Indian Patent Act says that any person who has invented it but wants to assign it to some other person, to an assignee, provided he is not able to himself get the patent or go to the office, then he can assign it. So this particular, the filing is also assignable. You can also assign it to another person. And that means the right is assignable. And if, for example, a partnership firm or a company, it is not a true inventor. It cannot be a true inventor because a firm or a company cannot invent anything. But a person, an individual can only invent. So an individual can assign its right of filing the application to a partnership firm or a company. So in that manner, it is right of filing it can also be assigned. So it is very clearly mentioned in Section 6(1)(b) of the Indian Patent Act that this right of filing an application is also assignable. You can assign it to an artificial person, because we know that individual is a natural person. A natural person can go and file for an application for patent or can assign it to an artificial person, a partnership firm or a company, so that a company or a partnership firm can also apply for or file an application for obtaining a patent. The third is a legal representative. Who is a legal representative? A legal representative is a person who in law represents the estate of a deceased person. For example, anyone who has invented something and has expired or died, then he or she can assign this right to an heir before dying. When he is not assigned during his time of living, the person who has actually inherited from it can also go and file an application for obtaining a patent. So a legal representative is a person who has been assigned by the person who has actually invented while he was living, or even posthumously if he has not assigned it but he has inherited it. The fourth is joint applicants. Now what do we mean by joint applicants? Joint applicants actually mean an application for a patent can be made by an inventor either alone or jointly with any other person. Either the individual itself can apply for a patent or can also apply jointly with a legal representative or a company or a partnership firm. So here you can also apply jointly. The other person can be a co-inventor or assignee of the inventor or a legal representative, or also can be a company. So joint applicants means that the individual who has actually invented plus the person who has been assigned, or can be a legal representative, or can be a company or partnership firm, or anyone whom he has assigned or allowed to file an application. Now there is no restrictions on foreign nationals to file a patent. Even foreign nationals can apply for a patent, can make an application and obtain a patent in India, but they have to be very clear that there is an address in India, or they have been practicing address of service in India. So any foreign national, even if I want to obtain a patent in United States or in other country, I can also apply it in other countries, but I have to show that my patent or my invention is having some service in that country, and I have an address in that country, and I will be using my invention in that country, because you just can't go and apply a patent in any other country just to block the invention. You have to be very clear that your invention is being used in any other country too, in the country where you have applied for a patent. Similarly, in India also, if any foreign national wants to apply for a patent, can file an application for a patent and apply, provided he or she has a place of staying or a domicile or a place of service. He can show that his or her invention is also applicable in this country, or is to be utilized in this country. Now the sixth one is application made through an agency. If a person can also authorize any other person to apply for patent on behalf of that person, provided that person is ready to has been signed, authoritatively signed by the inventor, and that person is also will also apply for that invention according to the person in the terms and conditions of the true inventor. So the person can authorize, but at the time of processing of the application, the person can change the authorization. At any time, the true inventor or the person who has actually invented can also change it. Say that, no, now I don't want you to authorize. They can take the authorization back and authorize it to another person, or it's himself or herself can also file for an invention. So we have seen that there are 6 to 7 people who can file for an invention. The first and foremost thing is that for obtaining a patent, you have to file an invention. First, you have to file an application. Now, where to file an application? The first is you have to apply for an application, write an application that you have invented something and you think that this thing is worth of invention, worth of getting a patent. The second thing is where to file. Now, the jurisdiction is also very important. The appropriate office where you have to file your application. The appropriate office means the location of the patent office where the application should be filed. If the applications are filed in a wrong jurisdiction, they are void ab initio. The meaning of void ab initio means that they are void from the point of filing it. From the time of filing, they are void. They may be considered to be void. So the territorial jurisdiction is a very important aspect which one should remember while filing an application. So here we'll also see that what are the offices. As we know that there are 4 major patent offices: Mumbai, Chennai, Delhi and Kolkata. Now who all can apply for or file an application in Mumbai? The people who are staying in the states of Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, the Union Territories of Daman and Diu, Dadar and Nagar Haveli, all these people, anyone who has invented in all this under the jurisdiction of Mumbai, living in these states, can file their application in Mumbai. Any people who are staying in the states of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, National Capital Territory of Delhi itself, and the Union Territory of Chandigarh. The people who are staying in these areas and have invented something and want to file for an application have to go to Delhi. So Delhi is the main office for people who are staying in these states. Chennai, people who are staying in the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu and the Union Territories of Pondicherry and Lakshadweep, they can file their application in Chennai. And the rest of India can apply in the office of Kolkata. So we have seen that first of all, we have to file an application. I have invented something and what I have to do, I think that my invention is worth obtaining a patent, I have to file an application. So filing an application is the first and foremost thing. Who can file? We have already seen. And where to file? The territorial jurisdiction is also very important, and we have seen that there are 4 patent offices which are located in Mumbai, Chennai, Delhi and Kolkata. So the rest of India can file their application in Kolkata, and the states which I have already mentioned under the territorial jurisdictions of Mumbai, Delhi and Chennai can only file in those places. If the territorial jurisdiction is wrong, their application will be considered as void ab initio. The meaning of void ab initio means that it is void right from the beginning of the filing of the application. It is also very important to understand that when we are filing an application, we also have to give some prescribed fee. Normally, it is understood that patent is very costly to obtain a patent. You have to file a huge fees for obtaining a patent. So, let's see that who are the people who are hugely charged and who are the people who are not charged very much. It's seen that individuals are not charged very highly, but a company or a partnership firm is always charged 4 times more than an individual. The reason we understand that a company or a partnership firm is going to earn a lot. Even the R&D, the research and development organizations and these type of organizations, they are going to earn a lot. That is why they are charged a huge price. They have to submit with a prescribed fees which is enormously large than the individual who is actually filing. Mostly what happens that an individual is not able to file a patent, an application. So they jointly file with some partnership firm or some or other organizations in order to reduce the cost. And when these organizations come with them, the cost on these organizations are very huge, for the simple reason that they will be earning a lot. On the other hand, an individual will not be earning that much because it has to finally give its patent to some other organization for exploiting the same. Now finally we come to the procedure of filing application. First we have seen that we have filed the application. We have second, who can file. Third, the offices where we can file. And fourth, how to file. What is the procedure? Now, the patent application in the prescribed form accompanied by the requisite fees has to be filed along with the provisional and, if possible, complete specification. Now, here I'll be very clear. I'll be telling you clearly what is the meaning of provisional and complete specification. You have designed something, you have invented something, but you're not very sure about your invention. You think that there is something lacking. Because when you're writing a complete specification, you have to be very clear about the claim, about the thing which you're claiming for. The claim is a very important aspect of complete specification. So when you're writing a claim, you have to be very sure what you are writing, what you are asking for. So normally what happens, what we do is that the person is not very sure about his invention, but he knows that this is something new or this has some advantages over the one which is existing. So what the person does, files a provisional along with the application. So there you file a provisional application, you file an application and a provisional specification. The provisional specification means that you do not have a complete thing over it. You have not completely written what you are going to obtain a patent for, but you have written something and you are blocking your invention. You're blocking your invention there, so that some other person may not come, because we have already learned that the first inventor is the person who will get the patent first, whose patent or whose application will be examined first. Two people can have the same invention, but the person who has filed first will get a patent. So we have to be very quick. I have invented something and I want to block my invention. I don't want my invention to be exploited by or used by somebody else. So what I do is that I go and file a patent application. First thing, I file a patent application in the territorial jurisdiction, the patent office, which is coming over my territorial jurisdiction. Then I'm not very sure about my patent, definitely. So what I do is that I write a provisional specification. I attach a provisional specification. Then after I file a provisional specification, I will be given a time of 12 months. Within the 12 months, I have to file my complete specification. What is the complete specification? Complete specification is actually the document where you will write down your claim. Claim is something which you are asking for. You are telling the patent office or the people, the people who will be examining you, that this is the particular invention. Your particular invention, because that has to be examined. Whatever you have written has to be examined. You should be sure about your invention. You must have gone through the lab test, must have gone through your a number of testing, and then you finally, whatever you have got, you are sure about it, because you are the inventor, so you're sure about your invention. You know that if it is a pharmaceutical invention, or if it is a drug, you must know that if I mix something, I will be getting this drug. If at the time of examination you mix something and you get something else, definitely you're not going to get a patent for that invention. So surety is a very important thing. And in the complete specification, you have to be very sure what you're writing for the claim. So you're not sure and you have filed a provisional specification, you are getting 12 months time to file a complete specification. The moment 12 months time has lapsed, your invention will no more be entertained. Your application will no more be entertained. So you have to be sure that within the 12 months you have to file a complete specification. After filing the complete specification, there will be a notification in the Patent Office Journal. You have filed a complete specification. Then, after the application is filed with the required document and fees, the date of application is allotted. Your date of application will be allotted and the application is published after 18 months. The time is very, very important. After 18 months in the Patent Office Journal. There is a Patent Office Journal where it will be published. So the complete specification, whatever you have written, will be published in the journal. Before that, it will be kept under the covers. It will not be shown to anybody. But after the 18 months time has passed, it will be published in the Patent Office Journal. So before that, it is requested to people who are actually inventing things that they should not go for any type of exposure of their inventions. They should keep the things in cover, go file for an application, and then wait for it to be published in the journal, in the Patent Office Journal. The moment it is published, after 18 months in the Patent Office Journal, the copy of the application and specification is made available to the public through the Patent Office website. Now, it is coming to the domain of the public. Your invention is coming to the domain of the public. So, anybody can see your invention, your specification. The contents of the specifications will be kept confidential up to the date of publication, only up to the date of publication. The moment it is being published, it all comes to the public domain through the Patent Office. Then you have to go for a request for examination. The applications are not examined till the request for examination is made. So the person who has actually filed the application has to go for a request for the examination of the same. If the request for examination can be made by any person or the applicant within 48 months from date of application. If you do not go for a request or examination, then it won't be examined. It is you who have to follow. So 48 months is the time. Within that 48 months, you have to go and ask for the examination of your complete specification, of your specification. If 48 months has passed or lapsed, or you have not asked for a examination, then your application will be treated or deemed to have been withdrawn. Your case won't be entertained. So you have to be very, very alert. First you have to file it. Then you have to file it in the office with a prescribed fee, then provisional application, then complete specification, then it will be published in the journal, and after publishing in the journal, what happens? You have to go and request for examination. So once you go for an examination, request for examination, it will be examined. The examination of patent application is taken up in the Patent Office only after request for examination is received. The applicant has to respond within 12 months of the first examination report. After one examination report, you have to respond within 12 months of the examination report. Now, if the application is found to be in order, patent is granted by allotting a serial number. Grant is then notified in the Patent Office Journal available on its website. After publication, patent specification and other documents relating thereto are made available to public. The applicant receives a patent certificate giving details of the patentee, title of the invention, date of grant. The entry of the grant is also made in the Register of Patents. So this is the way how you obtain a patent. But this process is very, very tedious. So we have to be very sure that we are following the same. The person who has actually invented is following its own case. If the application is found to be in order, what does it mean? If the application is found to be in order, it means that if there is no opposition from anyone, because once your specification is put in the website, anybody can come with an opposition, can oppose your patent, can say that this particular thing is mine, or there is a prior art, or come with a specific saying that I have invented it, or there is a patent which is already there working on this lines. So unless there can be a pre-opposition grant, once you are given a patent, that doesn't mean that you are through. Before there is a grant of patent, there is also a critical stage. It is a critical stage because when the examination is going on, anybody can come with a pre-grant opposition. So unless and until your patent is granted, don't think that you are through. Even if a patent is granted, within 12 months time, anybody can come and oppose your patent. So there is a pre-grant opposition and there is a post-grant opposition. After the procedure also, we have to be very, very sure that this patent can be opposed by anyone during the process of granting of the patent. Before that, somebody can come with an application and file before the registrar that this patent is I have something which can by how I can oppose this person, or I can oppose this patent. And then at that time, if the controller thinks that this patent, that the person who has come with a representation opposing the patent and the opposition is a valid point, then it can revoke the patent or say that yes, you can be given a patent, or this patent can also be revoked. After post-grant, after the patent is given also, somebody can come, any interested person. Now here we have to be very sure that person who is interested, not any frivolous person. Any person who is interested can give notice of an opposition to the controller within 12 months from the date of publication of the grant of patent and oppose it that this particular patent which has been granted has I have valid points to oppose this patent. And if the controller will put it to the opposition board, and after hearing the patentee and the opponent, the patentee has to defend oneself and the opponent has to defend himself by saying that his opposition is right. So here you have to defend again, and once you're through, the controller may either maintain, amend or revoke the patent. So it may be noted that the entire process from filing a patent application to the grant of the patent is a complex and highly legal, not only in India, but in other countries as well. And therefore, services of a patent attorneys are invariably taken to process patent applications in the patent office. So now, in this session, we have studied that what are the different methods to obtain a patent in India. We have talked about only India today. We'll be talking in the next session about obtaining a patent in other countries as well. For obtaining a patent in India, we have seen that first and foremost thing is you have to file an application to the appropriate office with a prescribed fee, with provisional applications, and if you're not very sure, and after the provisional application, within 12 months time, you have to file a complete specification. Then it gets published in the journal, and once it is published in the journal, you have to go for an examination. Once it has been examined and brought to the notice, and it is found that the patent is in order, or your complete specification is in order, the person is granted a patent. But before granting a patent also, there is a time when there can be a pre-grant opposition once you're through with the pre-grant opposition, or after granting of patent also within 12 months somebody can oppose your patent. After that also, if you're through with that 12 months time and you have defended yourself clearly, you have come out through, then you will be granted a patent. So it is not very simple, of course, but it is not very difficult too. For anyone who has invented, I'll surely say that we should not discourage but encourage, because patent is a right which encourages scientific inventions and a scientific temperament of persons. So definitely, if you are thinking that you have invented something and you want to go for a patent, please go. These are the steps which you have to follow. These are the stages which you have to follow. And with all my wishes, I say to all my students who are in this program who have enrolled in this program, that please watch these sessions. Again, I'll be coming with another session, and this is specifically for my students of postgraduate certificate in patent practice. If you'll be watching these sessions, it will always be beneficial to you. Thank you very much, friends, and I'll come again with another session on patent.